go ahead.
Hey everyone, welcome to another episode of the Good Deeds Note Investing Podcast, Open Mic Night. Tonight we are privileged and honored to have the lovely and talented Tony Sotilli from one of our favorite attorney offices, covering Kentucky, Indiana, Michigan, Ohio, and now Illinois.
That's right.
So yes, Tony and Franco Barilli are our two go-to people for any kinds of, collateral reviews, all the way through, unfortunately, sometimes obtaining the house itself.
Yep.
So, Tony is here tonight to specifically talk about the intricacies of bankruptcy, and I have really been looking forward to this because I have to admit, Tony, I've been sort of faking it on what I know about bankruptcy, so I'm hoping I'll really know what I'm talking about from tonight on.
Good.
And I love bankruptcies. So.
I'm a walking wounded because I have famously talked on the podcast about buying the only note I ever bought in Pennsylvania where I live was a serial bankruptcy declarer who declared bankruptcy 7 times in 6 years and was never stopped by any judge or anything else.
Oh my.
So, yeah, so I understand what Chris is talking about, but I also see like the dark side of it. So
sure.
Hopefully you'll be here to help us decide whether we're fans of bankruptcy or maybe not so much.
Well, I'm more than happy to try to sway you to the dark side, Gail.
Awesome. So I see already we've queued up your presentation.
Yes, ma'am.
Would love to jump in. Feel free if you would like to explain a little more for everyone what your agency does, what your law firm does.
Okay. Like Gail said, thank you for the introduction, Gail, and thank you as well to Chris for having me on your podcast. Both of you, we appreciate that. When I was approached to do this, the idea was to do kind of an introduction to bankruptcy. A little bit of 101, a little bit of question and answer, questions that I receive from note buyers and from other clients. So we'll get into that in a little bit. But Gail gave kind of a great recap of our firm. Franco and I joined forces after meeting at a previous law firm where we worked together. We joined forces about 4 years ago, 4.5 at this point, and started Sotilli and Barilli. We started pretty small with just really handling bankruptcy work and collection work. We had long since done foreclosure work, forfeiture work, real property, things like that. But we really wanted to focus on our core competencies, make sure the firm was going to stick around, and it did stick around. So that's we're blessed for that. We work hard. We try to do good work. And we appreciate everybody using our services. So we have spread around a little bit into some additional states. So like Gail was saying, we do all default-related matters. So that's foreclosure, forfeiture, collection, bankruptcy, all those things in Ohio, Kentucky, Indiana, Michigan, and Illinois. We also handle bankruptcy matters only in Wisconsin, Colorado, and Washington, D.C., and that's full bankruptcy matters. And then across the whole country, all 94 bankruptcy jurisdictions, we do what are called limited filer pleadings. So those are plan reviews, proofs of claim, transfers of claim. We'll talk about what some of those buzzwords mean as we get into the presentation tonight. So we've got about 30 slides or so. It helps if there's questions along the way. If we get asked a question that I know we're going to cover in a little bit, I might ask if we can pause that just to kind of put a pin in it and keep everything moving. But we can certainly handle questions along the way. So I appreciate your help with that, Gail and Chris.
Sure thing.
So we are going to cover a few topics today. We're going to cover who are the players in bankruptcy. Oftentimes, this is the trickiest part when we're training a new person in our firm. It's the terminology. It's who are the players, who's who. We're going to talk about Chapter 7 versus Chapter 13. Those are the most likely bankruptcies that you all will be a part of. You may see some Chapter 11 work, but probably not too much. Same thing with Chapter 12. Chapter 12 is for family farmers and fishermen. Out here in the Midwest, we see our share of those, a couple a month. Chapter 12s a month we would see. Chapter 9s are municipality bankruptcies, so like Detroit, Orange County, California, things like that. You guys won't handle those. And then Chapter 15 is cross-border bankruptcies. We won't even talk about that. Okay, so then we're gonna talk about some common terminology. So buzzwords you'll hear, in your circles, and when you talk with either myself or other bankruptcy counsel. We're going to do kind of a behind-the-scenes bankruptcy timeline. So I'm going to walk you through a Chapter 7 case and a Chapter 13 case, basically the timelines, what to expect and when. All along, we'll be talking about rights and remedies for note holders. I do have a few slides that I kind of specifically designated to that, just that really didn't fit anywhere else. We'll talk about that. And then what everybody also wants to know is, how much is this going to cost me? So tonight is free, but after tonight will typically cost. So we'll talk about some common pleadings, what you have to do, what you don't have to do. Our firm will reject work. We will tell you, hey, look, we don't need to do that for you. Save your money. We're not the type of firm that is after every dollar today. We're more interested in working with you all in 10 and 20 years from now than trying to get every dollar we can on a particular file. So it kind of makes us a little unique from some of the bigger firms out there. So we believe this is a team. You know, we've got our firm team and we've got our client team. So your goals are our goals. And, Chris, your goals might be different than somebody else. Gail might be different than somebody else. So we try to really listen and do what our clients want, what their goals are. So let's go right into it. So who are the players in a bankruptcy case and what are their roles? Okay, so we've got quite a few people here. We've got the debtors, we've got the judge, the local trustee, and the U.S. trustee, debtors counsel, and creditors counsel. Those are basically all the people you'll see in a bankruptcy case. So the debtors, you know who the debtors are, right? These are the people who file bankruptcy. They can be individuals or they can be a business. They could be single, married, incorporated, unincorporated. You got all kinds of entities that can be debtors. Bankruptcy judge, that's pretty obvious what the judge does. Most things in bankruptcy court are not done in front of a judge. I like to say, if I'm going to court, if we have to see the judge, we might have done something wrong. Now, I don't mean wrong like we shouldn't have done something, but what I'm trying to say is, if we've got a motion out there, we try to get those resolved. So we don't go before a judge. Judges are kind of wild cards. Even if we know we've got all the facts on our side, sometimes judges can be real wild cards. So we've got the judge. The judge is a party to all of this. Let's talk about the two kinds of trustees briefly. So you've got the U.S. trustee, okay? So the U.S. trustee kind of governs everything. They are looking big picture. The country is divided up into several different jurisdictions that different U.S. trustees cover. You will never see them. The U.S. trustee, they're really looking at big picture thing. They're looking at proofs of claim in general. They're looking at actions filed by certain creditors. Big creditors, not the smaller note buyers. They're looking to see how Ocwen is doing their pleadings. They're looking to see how Bank of America is filing their claims. They're looking for patterns, behaviors, things like that. They keep statistics. Occasionally they get involved in a case. Typically they'll get involved in a case when they don't like something. Whether that's a creditor thing they don't like or a debtor thing. So if a debtor's trying to pull a fast one, sometimes the U.S. trustee will get involved. So if the debtor's trying to file a Chapter 7 case and they make too much money, the U.S. trustee may get involved and want some proof that they should be in a Chapter 7 and not a 13, things like that. So then you get the local trustee. So in a 7 and a 13, both of those kinds of chapters of bankruptcy have local trustees. There's a lot more Chapter 7 trustees than there are Chapter 13 trustees. A whole lot more Chapter 7 trustees than Chapter 13 trustees. Typically, Chapter 7 trustees also have a side, a law practice. I almost said a side hustle, but they almost always also have typically it's a debtor bankruptcy practice. A lot of Chapter 7 trustees are also debtor attorneys. Several that I know that I not affiliate with, that I associate with, are creditor attorneys. So they're in the area, they're in the business, they're in the industry. Trustees can be your friends. Trustees can really help. You want to try to keep your trustees happy. You want to ask your trustees questions, not necessarily you all, but your attorneys typically have good relationships and want to have good relationships with the trustees. Creditors Counsel, that's me. So I represent the creditors, and that's really the last main party in a bankruptcy case.
Hey, Tony.
What's that?
I was just going to say one quick question. Is
Sure.
the local trustee really like the manager of the bankruptcy case? Is that
That's a very good point. The local trustee is going to oversee the bankruptcy estate. So yes, they kind of shepherd the whole process. They're wanting to make sure that the debtor's doing what the debtor is supposed to do. The creditors are doing what the creditors are supposed to do. The local trustee hears testimony at the 341 meeting of creditors. So whenever a bankruptcy is filed, there is always a meeting of creditors. It's called the 341 meeting of creditors. 341 meeting the bankruptcy code section that has debtors come to a central place and be put under oath, and they testify to the pleadings that they filed. Now, at that meeting, creditors can come. Typically, creditors don't come. It's more the unsophisticated creditor. It's the mom and pop landlord that are just renting out a room. Ex-spouses come all the time. That's always a hoot. Business partners that, and businesses that went south. Those are the kind of folks that go to 341 meetings. But yes, the local trustee really shepherds everything through and makes sure all parties are doing what they're supposed to do. So that's all the parties. I put a slide together that really talks about those a little bit more in depth. Chris, Chris or Gail, do you guys disseminate the slides?
Yep, we'll share them.
Okay, wonderful. So that's why I put this in here. I think a slide is kind of worthless if it's just got what I had on it originally. So even though I didn't want to pollute the slide with all of this stuff, I put an extra one on there. So if you get this is just kind of a good, good basic, simple definitions of what everybody is. So we'll move on to the differences between 7s and 13s. Okay, some of these topics we're going to cover pretty quickly. The who's who, that's kind of a quick topic. So let's get into some differences between between chapters 7 and 13. And like I said before, that's really all we're going to cover tonight. So Chapter 7, okay, liquidation bankruptcy. That's what most people think of when they think of bankruptcy. It's not as simple as the Office line where Steve Carell just throws his hands up in the air and says, "I declare bankruptcy." But it's close. Chapter 7 is pretty close like that. So the trustee is going to look at all of the debtor's assets and all of the debtor's liabilities. If there are assets that have value that the trustee can liquidate, turn into cash, and make distributions to creditors, that's what that trustee is going to do. So the debtor may have a house, the debtor may have a car, the debtor may have some jewelry, some clothes, obviously, retirement accounts, things like that. But what's that?
Retirement accounts, yeah.
Retirement accounts, oh yeah.
Can be rated, yeah, in a bankruptcy?
No, most retirement accounts, if properly funded, so long as they've not been putting an inordinate amount of money in there lately to
protect it from you.
to hide money, basically. Right. So long as they're just contributing into their 401k or their SEP IRA or some qualified retirement plan like that. Retirement plans are generally exempt from creditors. Exemptions are all state specific, even though bankruptcy is all federally governed. Exemptions are state specific. So a certain amount of money is protected in different states. we don't really need to get too in depth into exemptions. They really don't worry us in the creditor world too much. It's more of a debtor kind of topic. But just know that if there is some equity, if there is some equity in a house or a car, that's beyond the debtor's exemptions, that a trustee can force a sale of that and bring in money to the bankruptcy estate and then disseminate that to creditors. So it doesn't happen very often. 95% of Chapter 7 bankruptcies are what are called no asset cases. The debtor's already done this. The debtor's already liquidated. The honest debtor, the good debtor, has already done what a trustee would do. They've already gotten rid of the jewelry. They've already gotten rid of the fancy cars. They've tried to pay the bills. They've paid down what they can, and they still can't get out of it. So that's Chapter 7 bankruptcy. They're short, typically 4 to 6 months. It's the most common chapter of filing. One thing you need to know in Chapter 7 bankruptcy is there's no co-debtor protection. So all of my states are non-community property states. So this is where that really plays in. If it's community property state, really kind of ignore that no co-debtor protection because it's community property. But in my jurisdictions that are not community property states, if you've got two people who are on the deed, got a husband and wife that are on the note, and only one files a Chapter 7 bankruptcy, you can go after the other one, the non-filing co-debtor. There is no protection for that non-filing co-debtor. So there isn't a Chapter 13, and that's one of the big differences between 7s and 13s. There's a lot of big differences, but that's a big one. So we'll get to the co-debtor state protection here in a bit. But Chapter 13s are the actual title. You see it right there. It's an adjustment of debts of an individual with regular income. So individual is key. You're not going to see businesses file Chapter 13s. Regular income is key. That's why there's Chapter 12 for farmers and fishermen that are typically only paid a couple times a year. Chapter 13 debtor needs to have money coming in, typically wage income, Social Security income, disability income, money that they can count on receiving weekly, biweekly, monthly, in some regular fashion. It could be a borrower who also makes too much money and can't file a Chapter 7 bankruptcy. There are income limitations in Chapter 7 bankruptcies. Really
how much?
Go ahead, Gail.
How much before you can't do it anymore? How much?
It varies by state. It's actually a decent amount of money. I honestly can't remember exactly the number, but in Ohio, for example, I think it's in the high 40s. So, I mean, if you're making in the high 40s and you're the only person in your household, you can still file a Chapter 7 bankruptcy. Again, so long as your expenses, your allowable expenses exceed your income, you can do a Chapter 7. But generally speaking, you don't have to be destitute to file a Chapter 7 bankruptcy. You can have some money coming in to do that. So let's kind of try to stay on the creditor side if we can. Otherwise, we will bog down in debtor world, which I did do for my first couple of years as an attorney. So I do have some experience with that as well. So back to Chapter 13s. So the debtor is going to reorganize their debts through a court-confirmed plan. Okay, so now that's what you're hearing about in a Chapter 13 bankruptcy. What does the plan say? What's the plan? And we're going to talk about plans when we talk about different terminology. But just know that that Chapter 13 bankruptcies are going to last you 3 to 5 years. They last a very long time. Only about 27%, less than 30%, complete. Chapter 13s are difficult to complete all the way through discharge. And it's because they're 3 to 5 years, if you ask me. They need to be, I understand that. But a lot of Chapter 13s fail, which is frustrating. Some jurisdictions do a lot better than others. You've got some very, very, very good Chapter 13 trustees out there that really take their shepherding of these cases seriously and do an excellent job of getting all parties involved. Then you've also got some Chapter 13 trustees out there that are strictly by the book. If you're not doing X, then Y is going to happen. If you're not doing A, then B is going to happen. And they don't see a lot of gray. And those tend to fail a lot more because, again, it's 3 to 5 years. I mean, if you think about your own household, a lot can happen to your own household in terms of income and expenses over the course of 3 to 5 years. So it makes it difficult for borrowers. Reviewing and understanding these plans are very important. And like I said, we're going to cover that in another section here. There are debt limits to a Chapter 13 bankruptcy. I put the numbers up there. They're weird numbers because they're adjusted for inflation. But these numbers are pretty important because for someone to file a Chapter 13 bankruptcy, their unsecured debt must be less than about $395,000, and their secured debt must be less than about $1.18 million. So they sound like really big numbers, but unsecured debt less than about $400,000, that's a bad hospital bill. I mean, that can accumulate very, very quickly. So these numbers, if a debtor needs to file a Chapter 13 bankruptcy to reorganize their debt and pay off arrears and things like that, and they have more debt than these limits, then they have to file a Chapter 11, which is extremely expensive and extremely complicated. So there's a big push to always up these numbers and make them a little more, get more people into Chapter 13s and keep them in houses. Don't force them in 7s or don't force them into Chapter 11s. So those numbers are pretty important. Again, not really for our perspective, but I just want to give you guys an idea of what a debtor looks like in a Chapter 13. So a big thing in Chapter 13 bankruptcy is you have co-debtor protection. So that same husband and wife, and only the husband filed a Chapter 7 bankruptcy, you can go after the wife for collection purposes. In a Chapter 13, if only the husband filed a Chapter 13, you can't do anything with the wife, even in non-community property states. That non-filing spouse, that non-filing person has co-debtor protection. So it doesn't mean you can't go after them. It just means you have to go through the court to do that. So you have to seek relief from the co-debtor stay. We'll talk about some of those as well. But that's another big reason why people file 13. So people file 13s because they've got a rearage on property that they want to keep. People file 13 because they have too much money coming in. People file Chapter 13 because they're trying to protect a co-debtor. I see it a lot with student loans. I see it a lot with mom or dad co-signing for a car loan. Not really so much on houses and not so much on real estate, but student loans and cars are very, very big. So that's really a 30,000-foot view of the differences, the big differences between 7s and 13s. Really, any one of these slides, and I do a lot of these slides for different folks. I honestly could spend an entire podcast on basically any one of these slides, but just want to kind of give everybody the basics, give everybody the differences between the two chapters.
Hey, Tony, will you later on go through the differences of owning a note when it's in Chapter 7 versus Chapter 13? Because I know there's some differences there, or should we talk about it now?
Well, we can talk about it. Let's talk about it later. Let's see if we cover that as we kind of get through some things. So let's talk about some common terminology. Okay, so the automatic stay. You heard me talk about the stay. That goes into effect when the bankruptcy is filed, okay? So when that debtor files bankruptcy, nothing else needs to be filed. The simple act of filing that bankruptcy brings about the automatic stay. It bars all collection activity. So you guys are going to see this, and this is a good point to your point before, Chris, with owning notes in 7s versus 13s. Typically, if you own a note and it's in default and you've got foreclosure proceedings going on, somebody's going to file bankruptcy, right? So they're going to typically file that on the eve of a sale date. I see that very, very often. It's a completely legitimate. As much as we don't like it, it's a completely legitimate tactic that borrowers use. And in a Chapter 7 bankruptcy, if you want to keep that property, you have to be current on it. Otherwise, we can seek relief from that automatic stay. And we're going to talk about that. Those are MFRs. If you hear an attorney talk about an MFR, a motion for relief from the automatic stay, we're going to talk about that. But in a Chapter 13 bankruptcy, if you own that note that the borrower is behind on, you've got to wait a little while. You've got to wait until that plan kicks in. You've got to wait until that trustee starts dispersing payments. It's a little different. No two cases are the same. Everything is very, very specific, case specific in bankruptcy, which just adds to the frustration. So back to the automatic stay here. We kind of talked about this next line here. So you must seek relief from that automatic stay to continue with your collection or recovery efforts. So like I mentioned, in that Chapter 7 case, if they're behind, you can go straight into bankruptcy court and ask for relief from the automatic stay. You don't have to wait. In a Chapter 13 bankruptcy, you do have to wait. You have to wait a little while, and you've got to see what that plan says. You've got to see what that debtor's trying to do with that property. You have to give them a chance to succeed with that plan. If they don't, if they say they're going to pay you and they don't, well, that is cause for you to go into court and ask for relief from stay. And you just prove to the court, now this is all through your attorneys, you just prove to the court that there was another default, that there was another instance where the debtor did not pay, and you want relief from stay to be able to collect and to be able to collect your property back in state court. So that's a big difference, like you were asking, Chris. So kind of as we're going along, that's something that I'll make sure to kind of hit on.
Right. So I just want to say, for people who are kind of hearing a lot of this for the first time, one of the most important things to remember as a note investor, if you have a borrower that you're attempting to get, to reinstate or just be more regular in their payments, you basically, if they declare bankruptcy, you cannot contact them at all. You cannot have someone contact them. There is no contact except from your attorney to their attorney.
It's a very good point, Gail. That's an extremely good point. All collection activity stops when that bankruptcy is filed. So it's not just you got to stop the foreclosure. It's you can't call and ask where the payments are anymore. You can't send a letter and say, where's the payment? You can't do that. You've got to get an attorney.
I can't even ask them, what are your plans?
Yeah, you can't. You really can't. If they're pro se, if they're representing themselves in the bankruptcy, then you've got a little more wiggle room. But you still can't ask for payment. It has to be voluntary at that point. You've got to let the court take over. You've got to let the attorneys take over. The creditor attorney take over in that case.
Yep.
So all collection activity has to stop. Okay, so multiple filings within a year. I just want to cover this very, very briefly because people hear about this and think this is a kind of a way out of bankruptcy, if you will. It doesn't really work like that, but so you heard me say that when that bankruptcy is filed, that automatic stay goes into effect. Well, that's not always true. If the debtor has already been involved in one bankruptcy within the last year before the next bankruptcy, before their current bankruptcy, if they've been involved in a case and now they're in another case within the last year, that automatic stay is only in effect for 30 days. So they only get a 30-day reprieve from creditors contacting them. Now, what's going to happen is that debtor is going to file to extend the automatic stay. It may upset you. You may get ticked off. The debtor, they just got out of a bankruptcy. Now they're in another bankruptcy. Now they want more stay protection. This is an instance where 99 out of 100 times, I would say, I'm going to tell you, just let the stay get reinstated. Let the stay extend. Okay, let the stay extend beyond that 30 days. They've got to file a motion, the debtor does. You have the right to object. You have your right to a day in court. But what this is basically doing is it's giving the borrower another chance. And judges are almost always going to give the borrower another chance. So that's one filing in the past year before the current filing. Now, if there are two or more filings in the past year before the current filings, and I see this all the time. Gail, you talked about this with your note in Pennsylvania. If there are 2 or more filings before the current filing, the automatic stay does not go into effect. And in order for that borrower to get stay protection, at the same time they file that bankruptcy, they need to file a motion to implement the automatic stay. And that's typically filed with a shortened objection timeline, typically just a matter of days instead of a matter of weeks. So you have to act quickly on these motions. Get them to your attorney, alert the court, whatever you need to do. You need to slow the debtor down on this. Now, they may have a good reason why they filed a 3rd bankruptcy within the last year. They have to attach to that motion to implement the automatic stay. They have to attach an affidavit that talks about why this case is different than the other cases. So talk with your attorneys on this. If it's worth objecting to, we can object. We have some success with objecting. I will tell you, though, it's difficult to win these, assuming there's no fraud, assuming there's no dirty dealings or anything like that. Assuming it's just a down on their luck debtor who's filed a 3rd bankruptcy in the last year, then there's not a whole lot we can do. An area where we do have some success, though, is we will object to that motion to implement. But what we'll try to do is we'll try to work out a scenario where, okay, we will let the stay be implemented here. We will let there be stay protection. We will give this debtor a chance. But in return, we want a 180-day bar against them refiling if this case gets dismissed. So what we're basically saying is, okay, we'll give you yet another bite of the apple, but if this doesn't work, then we want 180 days or a year or whatever we know we can get or what we can shoot for in that court. We want that in order to give you this case. And we do have some success with that. And that's a good tool in our arsenal to guard against multiple filings within a year. Then you have the downright abusers. I mean, Gail, it sounds like your person in Pennsylvania was just an abuser of the system and just filing nonstop. And there are ways to prevent that from happening. Well, not prevent it from happening. There are ways to combat that. You can't prevent it, but there are ways to combat that. And we won't really go into that too much today because, again, it's very case specific. But you got to watch those multiple filers within a year. So that's the automatic stay. The bankruptcy estate, I'll just kind of throw that up there. You can read that. I won't bother. It's basically just all the property that the debtor has an interest in, okay? Even if it's owned or held by another person. That's the bankruptcy estate, and that's what the trustee, that local trustee, is kind of in charge of. They're in charge of seeing what comes in and goes out of that estate. So you'll hear estate. You'll hear bankruptcy estate in the bankruptcy world. You'll hear the word petition a lot. So that's just the document that's filed by the debtor that opens the bankruptcy case. That's kind of the first pleading that's filed, the voluntary petition page. It's only a couple of pages, but that petition is usually accompanied by a lot of schedules and a lot of forms. But the petition itself is just a couple of pages, and it's an official form. A lot of bankruptcy is done on official forms, and the petition is one such form. So discharge, okay, this is what the debtor wants when they file bankruptcy, okay? It's the debtor's release of liability on their unpaid debts. So in a Chapter 7 bankruptcy, they're not making any payments on their unpaid debts. They're not making the payments to the mortgage company if they're surrendering. They're not making payments to the Visa bill, to the doctor bill, to the car company on the repo. They're not. And then after 4 to 6 months, if they do everything correctly, they're going to get a bankruptcy discharge. And then once that debt is discharged, it can never be collected again. And that's important to know. Once that debt is discharged, it can never be collected again. It's different than a dismissal, okay? A bankruptcy dismissal is when a case gets dismissed. We talked about Chapter 13s get dismissed all the time. Very few Chapter 13s complete and get a discharge. A lot of Chapter 13s get dismissed. And basically, that just puts you right back into the spot you were in before the case was filed. If you were on the eve of a foreclosure sale, if your attorney was garnishing their wages, you can go right back into court and garnish wages. You can do all kinds of things like that with the dismissal. But a discharge is very, very different. And in a Chapter 13, like we talked about, they're going to make some payments to the visa company, some payments to that repossession. Not much, pennies on the dollar typically. But at the end of the day, if they've completed their plan, the amount they have not paid is discharged, just like all of it in a Chapter 7. So now we're going to talk about the plan a little bit. So a Chapter 13 plan has to be filed within 14 days of the bankruptcy being filed. Usually they're done at the same time. All these debtors that file, these attorneys that file bankruptcies for borrowers, for debtors, they have a software that they use. And the software basically generates all of these documents and helps them file them all at once. So generally speaking, you will see the bankruptcy plan filed on the same day that petition is filed. The court can grant an extension. So debtors can ask for additional time to put that plan together. So maybe, again, in our context, we're on the eve of a foreclosure sale. We're getting ready to take that property back, and they file bankruptcy. They may not know how they're going to repay that, but they know that debtor knows they need to file that bankruptcy before the gavel falls at that sale the next day. So they're just going to file their bankruptcy. And if they can't put that plan together within 14 days, they'll ask the court for some additional time. Again, something we can object to, but they're going to get additional time. So, go ahead.
I was going to say, a question came through regarding discharge in regards to, in a Chapter 7, if it's discharged, basically the question is you can't file a judgment. If there's a Chapter 7 bankruptcy and it gets discharged, basically you can't go after that person for that debt anymore, correct?
That's correct. That debt is discharged forever. It can never be reinstated. It can never, you're not looking for statute of limitations issues, nothing like that. They get a discharge on that, it's done. Now, you don't lose your lien, you don't lose your property. I hear that sometimes from people that think in bankruptcy that means you lose your house. You, the note buyer, you don't lose your house. You have every right to collect that house back. You just have to do that then through state court. And your remedies are limited to getting your property back. You can't go after the borrower for any deficiency after a foreclosure sale or anything like that. Your remedy is limited to getting your property back.
And I think some people might be confused too. In a Chapter 13, when it's discharged, that just means a person's made all the payments based on, whatever their arrearages were and whatever the plan stated. You don't lose the rest of the UPB or the rest of the payoff when the Chapter 13 is paid off. Correct?
No, correct. The only way the main way a note is extinguished or a note is discharged in a Chapter 13 bankruptcy is if the debtor doesn't want the property anymore. If relief from stay has been granted, that is discharged in a 13. But in most cases, a mortgage or a note is long-term survivable debt. So that survives the bankruptcy discharge in a Chapter 13 bankruptcy. And that's a big difference between 7s and 13s and holding paper in both of those chapters. In a 13, if that borrower wants to keep that property and they make their payments and they get a bankruptcy discharge, they're still on the hook for that property.
Yeah, I think what's a little tricky to understand is in a 7, and correct me if I'm wrong, people worry about the lien being stripped from the borrower, and essentially it is like the borrower has no more personal responsibility for paying off that mortgage, but like you're saying, the mortgage doesn't go away, it's still on the house.
Correct. The lien still exists.
Right.
You just can't collect from the borrower any longer.
Yes, you can't chase them personally, but you can.
Correct. That's exactly right. That's called in personam. You can't go in personam anymore in your underlying state court action. You have to go in rem. You can only go after the thing. You can only go after the property.
And you could negotiate a new deal with them if they want to stay in the property.
Yes, that's up to you whether or not you want to do that. Correct.
Having shown their true colors.
Yes.
Think carefully about doing that.
So to keep things moving along here, if you don't like the treatment in your bankruptcy plan, you must object. Okay. We're going to talk a little bit more about plans in the upcoming slides, but if there are things in that plan that you don't like, for example, they want to pay you $100 a month on your note, and then in month 60, so the last month of their bankruptcy, they're going to pay off the debt. If you don't like that, and you probably don't like that, you have to object to that plan, okay? If you don't, and that plan is confirmed, then you're stuck with that. You're stuck getting $100 a month until month 60. And good luck getting a nice big lump sum in month 60. So you've gone 5 years getting $100 a month. These are very timeline, very deadline driven, and we're going to talk about this when we do some timeline discussions here next. There are timelines for all of this that your attorneys will help you with. They will help you review the plan. They will review the plan for you. This is what we do. We provide you with an analysis. We boil that plan down to what that debtor is trying to do. We'll make suggestions on whether or not you should object, and kind of go from there. So it's not something a layperson should really be messing with. So you don't have to use us. I'm certainly not. I mean, I'll pitch our firm over everybody any day, but just make sure you get some help with reviewing a plan. It's very, very. It could really mess your world up. If you don't know what you're doing. So, like I said, we'll talk a little bit more about plans here when we do timelines. I want to cover proofs of claim very quickly. A proof of claim is what it sounds like. It's a document that you file in bankruptcy court. Typically, your attorneys are filing it that proves your claim. Okay. So what that means is we are filing a document with the court, and we are attaching certain appendices to them. So we're going to attach the note, the mortgage, any assignments, any endorsement to the note, an allonge to the note. We're going to attach arrearage information. We have to prove up the arrearage. So there's a lot that goes on in these proofs of claims. They must be filed in Chapter 13 cases. If you've been around long enough, the general consensus was since you have a recorded lien on the property, you don't need to file a proof of claim and you'll get paid. That's not the case anymore, okay? It is a bright line rule now that says if you want to get paid in a bankruptcy, you have to file a proof of claim. And that goes for all Chapter 13 cases. Typically, you're not going to file a proof of claim in a Chapter 7 case. It's pretty rare that you'll file a proof of claim in a Chapter 7 case. Again, getting into the specifics, I don't want to really slow everything down too much. Always in 13s, sometimes in 7s. That's what you should remember from that. Courts require additional documentation. We talked about that. So that's going to be a copy of all the mortgage, note, deed, those kinds of things. It's used for pre-petition arrears and to show the ongoing payment. Okay, so part of that proof of claim is on that day that bankruptcy was filed, this is how much that debtor was in arrears. It's a snapshot. It's a financial snapshot on that day. Anything that was behind on that property by the day that bankruptcy was filed needs to be on that proof of claim. So if it's an escrowed loan and an escrowed account, and you've advanced taxes or you've advanced insurance, things like that, and then they file bankruptcy, now's the time for you to put that stuff on a proof of claim, okay? If they file bankruptcy on Monday and on Wednesday you're paying taxes, that does not go on a proof of claim. That's something different, and that's for another day as well. Anything pre-petition goes on that proof of claim. And then that proof of claim also shows the trustee and the court and the world what the ongoing payment is. And then that starts the process with the court. The trustee's going to disperse that amount. The trustee's going to pay that arrearage amount. The debtor may not like your proof of claim and they may object to it. The trustee may object to your proof of claim. But a properly filed proof of claim is incredibly important. And you have to have it filed no more than 70 days after that bankruptcy was filed. So it is a very quick timeline. Used to be about 130 to 140 days from the time the case was filed. And it was very confusing. It was just very confusing. So now there is a bright line, 70 days from the day the case was filed. You have to have that proof of claim on file. You have an extra 50 days if you need more time to get your loan documents in order. If you're still waiting on that recorded assignment, if you're still waiting on the allonge, if you're still waiting on things like that, we can petition the court for an extra 50 days for that and then amend the proof of claim within the 50 days after the 70 days. But our firm pushes very, very hard to get these done within those 70 days. It helps you, it helps the debtor, it helps us, it helps everybody to get these claims filed as quickly as possible. That is a very quick overview of proofs of claim. I have literally spent days talking about just proofs of claim, and they're complicated. We do them in all 94 bankruptcy jurisdictions. We spent about a year putting together all of our jurisdictional rules and what needs to go into these proofs of claim in all these jurisdictions before we took a single proof of claim in a jurisdiction that we don't practice in. So we.
Okay, let me just ask you something. Are you saying that you can do a proof of claim anywhere in the United States?
Anywhere in the United States, yes, ma'am.
Okay, did not know that.
All 94 bankruptcy jurisdictions.
Right, and is attorney pricing to do a proof of claim kind of standardized the way supposedly foreclosure fees are standardized?
That is a very good question. We're going to cover costs at the end, but I will tell you now, yes. There are Fannie Mae fees. So on the foreclosure side, you're familiar with the Fannie Mae foreclosure rate, the Fannie Mae foreclosure fee. Fannie Mae has numbers for bankruptcy cases as well. I have a slide on that, and we can kind of break that down a little bit. But yes, for example, a proof of claim and a plan review, it's a bundled service. So that debtor files bankruptcy, you're going to get notification of that bankruptcy. You give us a call. Give your attorney a call. Give somebody a call who can take a look at that bankruptcy. They're going to review the plan, and they're going to work with you to file a proof of claim. That's $650. That's a bundled fee. It should be the same that you're getting charged basically everywhere, because that's clarity in billing. That's what these Fannie Mae fee guidelines really give attorneys and give investors, clarity in billing. Now, that $650 is going to get your proof of claim and is going to get your plan review. Most of these Chapter 13s also have arrearage. Okay, they're behind on the property. That's why they're filing a bankruptcy. In order to complete a certain attachment to that proof of claim called the 410A attachment, and that's basically a loan history, a default history on the loan, your attorneys are going to charge you an extra $250 for that. So that's why you typically see $900 for a proof of claim. That's an easy number to budget. You budget $900 for a proof of claim. But that $900 gets you a plan review, a proof of claim, and your Form 410A completed. So that answers that question for you briefly, Gail.
One thing I want to mention, Tony, too, for people listening, this is kind of like an intro 101. We do plan on having Tony come back at a later date and actually go into Pacer and look at a proof of claim, look at things that you should be looking at, kind of a little more advanced course of a lot of this stuff. So you may hear it and wonder what it is. We are going to have another, I'll say a follow-up on this that shows you those things. So you'll probably end up seeing that and coming back to both of them. But I just want to let you know, there's a lot of verbiage being tossed out there. There's going to be something that will show you what all that stuff is on another episode. Yeah,
I'm just curious if you ever strategically drag your feet on doing a proof of claim. If you have someone who tends to, so in the case of my guy, the county tax sale is at the end of September. So this guy would always declare bankruptcy right before the tax sale. And then he would fail to create the plan or do anything that was required, and he would fall out of the bankruptcy, and then we would just repeat the process the following year. So like when someone has a pattern like that, I assume you don't rush to do a proof of claim because you sort of know it's just a giant joke anyway.
Yes, I'm just concerned that this happened so long in this case, Gail. I'm surprised that nobody went to court and said, Your Honor, this is the third time they've done this. This is the fourth time. I'm just utterly shocked that
I've complained at length about I had a very inexperienced attorney. I'm convinced, and I didn't realize it.
And that's going to happen, and that's going to happen. If you find an attorney you like, stick with that attorney if you can, or ask that attorney for recommendations. I do proofs of claim in Missouri, for example, but I don't practice law in Missouri. So if we do a proof of claim and we're doing a plan review in Missouri for you, and our plan analysis is that you should object to the plan, I can't object to that plan in Missouri because it's not a state that we're licensed in. So I'm going to tell you, talk to your Missouri counsel and they can object to that plan for you. Right. If you don't have Missouri counsel, I can point you in the direction of somebody. I see these questions all the time in the Facebook groups, and I try to chime in when I can if somebody's looking for counsel in a place where I have trusted counsel that I refer matters to. So.
Yeah, Chris said my attorney was a divorce attorney, and I believe he is correct about that.
Yeah, and that's frustrating. And Gail, I feel your pain with that. It's bankruptcy. I mean, I've been doing this for 15 years. I learn new stuff every week. I mean, bankruptcy is always changing. It's always changing. It's always adapting. No two cases are the same.
Right.
It's not something you dabble in. So if you've got, you get somebody like that handles divorces and they want to do a little bankruptcy on the side because they think it's easy money. It's not. That $900 goes real quick.
Yeah. Well, I really understood after 2.5 years of this what I should have done, which is call the sheriff's office in the county where this was happening and ask them who does all the foreclosures. And I assume in the states where you are practicing, your name would come up very often.
Yes, and you would see people in Pennsylvania as well, just like that.
Mm-hmm. Yep.
So let's move on. And I'm sorry, what was that?
No.
Okay, I was going to say let's talk about a little bit of timeline action here. So I want to lay out some assumptions here because everybody wants to know timelines, but again, virtually every bankruptcy is different. So here's what we're going to assume. In the next few minutes here when we talk about timeline. So we're going to assume that that we're only covering 7s and 13s from a high viewpoint like we've talked about. Bankruptcy is very circuit, district, division, judge, and trustee specific. So I'm going to use very broad general timeframes on things. And again, I always put my little disclaimer on there. Each one of these slides could be its own presentation. So Chapter 7's, briefly, a creditor's perspective. So, pre-filing, okay? So that debtor's going to see an attorney. Typically, when they go to see an attorney, that attorney's going to tell them, hey, look, you can tell your creditors that you're filing bankruptcy. But as a creditor's attorney, and as talking with creditors on this podcast here, until that bankruptcy is filed, you can do whatever you want. You can collect, you can file actions, you can get judgments, you can do everything until that bankruptcy is filed. So just because they tell you, oh, I'm going to file bankruptcy, here's my bankruptcy attorney's name, until they have a bankruptcy case number, that generally speaking means you can keep going with what you're doing. The debtor's going to complete their pre-filing credit counseling, and the debtor signs all their paperwork. Okay. Now, I talk about this pre-filing stuff in case we ever have to go back and look at some of this paperwork if we think there's some kind of fraud involved. I do a couple of these cases a year. Our firm handles some of these cases. I will go back and ask a debtor. I'll go to a 341 meeting of creditors and say, well, when did you see your attorney? When did you take this credit counseling? So this is important to our timeline, not usually, but on the case where we're trying to prove some kind of fraud, some kind of surreptitious behavior, hiding an asset, things like that, we may really care about when they completed their pre-filing credit counseling, when they signed their paperwork, when they first went to see their bankruptcy attorney. That may lay a case. I see it more, it's really more of a car issue than it is a real estate issue. Buying a car and then filing bankruptcy the next day. Did your attorney tell you to do that? You can't do that. It's not, like I said, it's not so big on the real estate side, but it could be important. So day one, let's start with counting days now. So on day one, that bankruptcy case is filed, automatic stay goes into effect, and the judge and trustee are assigned by the clerk of the court. So it's a draw of the hat, basically. That all happens on day one. Now, for the next couple of weeks, up to about a month, so between days 14 and 30, okay, all the creditors that were listed will get notice that the bankruptcy was filed. You will get served a copy of the filing. In a Chapter 7 bankruptcy, you should be reviewing the statement of intent. Every Chapter 7 bankruptcy has a statement of intent. What does the debtor want to do with your property? You have to look at that statement of intent. What do they want to do? Do they want to keep it? Do they want to surrender it? What are they trying to do with it? I'm not going to get too much in the second lien position on this 101 kind of presentation, but there's things to keep in mind if you invest in seconds when it comes to 7s and 13s. So take a look at that statement of intent. What does the debtor want to do? Are they current? If they want to keep the property in a Chapter 7, I always suggest you doing what's called a reaffirmation agreement. Okay, a reaffirmation agreement is an agreement that you enter into with the borrower. It's another promise to pay on a debt that would otherwise be dischargeable. So we talked about this before, right? When that debtor gets their discharge in a 7, that debt is discharged. There's no more personal liability on that debt. If they sign a reaffirmation agreement and they get a discharge in that bankruptcy, that debt is not discharged, okay? That's big. If you ask me, and I don't buy and sell notes, I don't counsel on buying and selling notes. I'm the attorney on the back end of those deals, but it just strikes me that makes your note that much more valuable if you've got a reaffirmation agreement on that Chapter 7 bankruptcy. That's something that your attorney does. Your attorney will fill out the reaffirmation agreement, will solicit the borrower through their attorney to sign that reaffirmation agreement. And then it has to be filed prior to the discharge being entered, all the way up until that day. You have to get that reaffirmation agreement filed. We'll cover reaffs a little bit later on, but that's what you should be thinking a couple of weeks after that bankruptcy's filed. Now, MFR I put on that screen, okay? If the debtor does not want to keep the property in a Chapter 7 bankruptcy, nothing is going to devalue that property more than a debtor who does not want to pay for it and does not want to keep it. So my advice, even though a Chapter 7 bankruptcy is only 4 to 6 months, things can hold that up. My advice is if that bankruptcy is filed and that statement of intent says surrender, file that motion for relief from stay, get that property out of the bankruptcy estate and right back into state court. You're not going to get any money from the borrower. That's not going to happen, but you're going to get your property back out of foreclosure sale or after the forfeiture's over with, whatever process we're in the state court. You can wait. You can wait until that bankruptcy's discharged and closed and then go back into state court, but you're looking at many, many months and that property continues to devalue. So again, this is a plug to seriously consider spending some money on legal fees and getting that property out of the bankruptcy estate as soon as possible. So that's about the time frame you want to look at doing one of those.
Tony, if they say they do want to surrender it, can you make a cash for keys offer at that point?
You are not able to do that. You have to get relief from stay before you can do that. You are disposing of the property. You are transferring the property. You cannot do that. Everything has to be cleared through the court. Once you get relief from stay, then you can do that all day long. Then you can solicit for a cash for keys. That can be part of a motion for relief from stay. I've put that in motions for relief from stay, that we are interested in a cash for keys, those kinds of things.
Mm-hmm.
But you cannot do that without relief from stay unless and until that bankruptcy is discharged and closed. So several more months down the road.
Okay.
So REAF's got to be filed prior to the debtor receiving their discharge. So around day 120, the debtor's going to get that discharge. So that's about the 4-month mark, day 120. So the debtor's going to get their discharge, providing there was no asset that the trustee recovered, providing that the debtor has got a no asset case, which is the vast majority of Chapter 7s, then the case is going to close a couple of days later, generally, within a month. Post-discharge, so some things you need to keep in mind after that discharge is entered. You want to make sure that account is updated from the bankruptcy case. So if it was discharged in bankruptcy, make sure you're not trying to collect from them anymore. If it was reaffirmed, make sure that if you changed any terms of the loan, that you're collecting per the terms of that reaffirmation agreement. Again, it's a term of art reaffirmation agreement, but I believe they're invaluable to a Chapter 7 Chapter 7 note. Get a reaffirmation agreement signed, executed, and entered. Make sure to not be collecting on discharged debt. I can't say that enough. We've said that a couple of times on this, and I'll probably say it a couple more times. So make sure you're not collecting on a discharged debt. If the debtor wants to make voluntary payments, by all means, take the voluntary payments. And if the voluntary payments eventually pay off the note, if the note still existed, send them a cancellation of the note and it's done. Property's theirs. But that doesn't.
What if your servicer was just sending a monthly statement? Is that considered trying to collect on the debt?
No, because there are guidelines that say they have to send those monthly statements. Those statements should have bankruptcy disclaimer language on there that says if you're in a bankruptcy, if you've received a discharge, this is not an attempt to collect debt. It's merely to due to whatever is governing that.
The reason I ask is actually, perfect example is I have a borrower who 5 years ago had a Chapter 7. It's a land contract, and they had been making some sporadic payments and stuff. And, it's been 6 months, actually about 3-4 months without payment. And basically, I reached out to a certain law firm in Indiana who might be on this webinar right now. And basically, it was your office reviewed it and said, hey, we don't send a demand on this. We just send, I forget what it was actually that Franco mentioned, but it's not a demand for payment. It's actually like a demand to get the property back in a sense.
Correct.
Yeah. But
you're not demanding for payment. You're demanding your property back. Exactly. That's it for the timeline for a 7. Yes. Any questions on a timeline for a Chapter 7 bankruptcy? Pretty quick, 4 to 6 months. Most of your notes are going to be involved in 13s, in all honesty, because they're in default. And if a debtor's in default and they want to keep the property, they got to file a Chapter 13. So we're going to gloss over the pre-filing, or we're going to gloss over the day 1 because it's the same in both cases. Those dates could become important later on, but they're not really for our purposes right now. So we're into the next 2 to 4 weeks, okay? You've gotten a copy of the paperwork. You've been served. Assuming you've been listed, you've been served. We talked about by day 14, that Chapter 13 plan is going to be filed. It must be reviewed. And also by day 30, that debtor should start making their plan payments. Even though that plan's not confirmed, and we'll talk about that in a second, even though that plan's not confirmed, that debtor is supposed to start making payments to the trustee. Every trustee is different. Some trustees don't even want payments to start until day 45. Some trustees expect a payment on the day the bankruptcy is filed. But again, broad generalities, day 30 should be about the day that that debtor should start making their payments. About day 45 is when that meeting of creditors is held. It's the same timeline as in a Chapter 7. I just didn't put it in there. But that's about when the meeting of creditors is held. And that's a good date to keep in mind, because that is about the time when you need to be objecting to the plan, okay? There's going to be a time, there's going to be a date certain that you have to object to that plan. And keeping in mind, trying to talk about all these jurisdictions at once here, that's about day 45, okay? So that means before day 45, you had to have gotten this paperwork to your attorney to have that plan reviewed and be started on that proof of claim. You need to be well started, if not filed, with that proof of claim by this point, okay? Around day 60 or 70, unless that plan was objected to, that plan's going to confirm. So you're looking a little over 2 months in. If you didn't do anything to that plan, if you let that plan go through, you didn't object, you were okay with it, now that plan is going to confirm, okay? If there are objections to that plan, a lot of people are going to object to the plans potentially. You've got creditors that aren't going to like their treatment. And it's not just creditors that are owed money. It could be an ex that's owed some kind of disbursement. They could object to a plan. The trustee can object to the plan because the trustee doesn't like the terms that are in the plan. A lot of different people can object to these plans. And oftentimes, multiple people do object to plans. So these trustees have a lot of balls in the air trying to get these plans confirmed. A lot of deals are made, a lot of, deals. That's the easiest way to say it. A lot of deals are made to get these plans confirmed. And you want these plans to confirm after your objections are resolved and you're getting what you want. You want these plans to confirm because that's when you're going to start making money. That's when you're going to start getting these money from the bankruptcy. Okay?
Hey, Tony, quick question.
Sure.
That came in because I think now's the time to ask this when it talks about objections. And Sylvia asked this question because a lot of times you'll see when they file the plan, they'll put a value of a house that might be a little light versus what it's really worth. For one of two things. Sometimes if it's a first, they may try a cram down. And then if it's a second, they may try and get that completely stripped. And the question is really, how often do you see cram downs? And, the other question is, if your second gets stripped, do you have any remedies? So it's kind of two questions I just wanted to throw out there with objections, because that's typically when I've seen them, but just curious from your perspective what you've seen.
First lien position residential property cannot be crammed down. So if you are first lien, you generally don't care what value they put in there in a Chapter 13 bankruptcy. Okay, generally speaking, you don't care, because if you're first lien and it's their residential property, you cannot be crammed down. If you hold a second or a third, or God forbid, lower than that, you do care about the value, and that is something that you would want to object to.
Mm-hmm.
Different jurisdictions cover lien strips differently. Some jurisdictions allow you to do it in a plan. Some jurisdictions force you to file what's called an adversary complaint. But by and large, seconds need to be very concerned with value, and non-residential lien holders need to be concerned with value. So make sure you understand what your note is on and what the debtor is doing with that property. Let's put it that way. Does that answer that question?
Yes, it does. Thank you.
These are humongous questions. They're just very, very large questions that are not easily answered. So we'll do the best we can, and we'll keep marching forward. So by day 70, like we talked about, that's when you've got to have your proof of claim filed. By day 70. I even put it in caps. It's in caps there. By day 70. So day 70 through whenever. Now, don't forget, these last many, many years. So these are things that we need to watch after day 70. So you got to monitor for objections to your proofs of claim. We talked about that. Different people can object to your proof of claim. They may not think that the arrearage amount is right. They may not think that you've got the appropriate documentation attached. I see a lot of note buyers trying to save some money, filing their own proofs of claim. You're playing with fire when you do that. I mean, you're just playing with fire when you do that. I would advise, you don't even need to use me. I would advise you finding counsel and having your counsel file proofs of claim for you. They will monitor for objections to claim. They will work with you to get those objections resolved if they're filed. If a plan objection was filed, this is also the time that you're going to want to be working that plan objection. So To use your example before with the house being undervalued, so let's say you're in second position, and they're undervaluing the house, and you've objected to the plan. This is the time that you want to be working with debtors counsel to get that plan objection resolved. And it may not be able to be resolved. It may go to court, and the judge may have to decide. That's the dirty underbelly of Chapter 13s with seconds, is that if there is no equity outside of the first mortgage, outside of the first position, and you're in second position, you can be stripped. So valuation is very important to that second position note holder. And now's the time to be negotiating that, day 70 through, going on. After confirmation, okay, we got a couple of little timelines here on after confirmation. So again, in confirmation, if nobody objects, confirmation is going to be after about day 60 or 70. So if everything's sailing through just fine, now the plan's confirmed. So now you're going to watch for your payments, okay? Watch for your payments to come in. If the plan is confirmed on the 60th day, you probably got to give it 30 to 45 days before you see payments, okay? Payments take a little while. You're not going to get a payment the day after the plan's confirmed. Typically, you're going to see that a month and a half later. So watch for payments. If the debtor falls behind on payments, talk to your attorneys in those states. Okay, talk to your attorneys to see if relief from stay should be sought. Okay, it may be that particular jurisdiction, those trustees know that trustee takes 2 months, 60 days to make their first payment. So don't say that Tony Satilli said payment should come in on day 30 because it's in a jurisdiction where that trustee lets them go 60 days before they make the payment. Just trying to stay in broad general terms here. So that's something that your state attorney, your bankruptcy attorney in that state will be able to tell you. If the payment changes after confirmation, if it's an escrow loan and taxes are going up, something like that, insurance is going up that you're dispersing, you have to file a notice of payment change. Okay, and we're going to talk a little bit more about that, what that pleading is in a little bit. But if that payment changes, you must notify all parties. After confirmation, if you're selling the note, if you're acquiring a note after confirmation, you've got to make sure that we're getting a transfer of claim on file. Okay, if you're selling it or if you're buying it, that's a cost you've got to keep in mind. A transfer of claim is $125 typically. Okay. That's something that you might need to keep in mind if you're buying or selling a note after confirmation. Got to get that transfer of claim filed. And it's exactly what it sounds like. You are transferring that claim to you from the previous creditor. If you're looking to charge, what's that?
I'm going to say, it reminds me, Gail, we got to do that with that Wisconsin asset that I mentioned to Tony.
There we go. If you are looking to charge the borrower for any of the fees that you've accumulated in the bankruptcy, and some jurisdictions allow this, not all, but some jurisdictions allow you to charge the debtor for these fees, you've got to file a PPFN, a post-petition fee notice, or notice of post-petition fee expense and charge. They're called a lot of things. It's another thing about bankruptcy that complicates. There's different terms for the same thing. It's difficult sometimes, but I try to stay consistent with the terms that I use. So I try to use PPFN, post-petition fee notice. So if it's in a jurisdiction where you can get even if some of your fees are recoverable against the borrower, before you collect those from the borrower, before you assess them to their account, you have to file a post-petition fee notice. So now we're into months 36 through month 60. So now we're into the meat of the bankruptcy. It's just chugging along. Debtors making their payments. You got to continue to monitor the case. Eventually, that plan is going to complete. Okay, all the terms that they agree to in that plan will be done. The arrearage will be caught up. Various other things will have been met in that plan. It's not just the creditors that are paid in that plan. There's other things that debtor has to do in order for that plan to complete. When that arrearage is paid in full, okay, so at whatever point that arrearage is paid in full, a trustee, the bankruptcy trustee, is going to send out a notice to you that says they have paid the final cure. So the final amount on the arrearage has been paid. You must respond to that notice. You have 21 days to do so. The notice is very clear that you must respond to that. Trustees are starting to show cause creditors for not responding to those. So when that is issued, got to get it to your attorney and you got to get something filed. You may disagree. You may say, well, no, the debtor is not current. And we would need to prove that the debtor is not current. But generally speaking, if all payments were made on that arrearage amount, whatever was in your proof of claim, whatever was in the plan is going to be paid. And you'll basically just be filing a response that says, we agree. The final cure has been paid. The debtor is current. Eventually, the debtor is going to receive their discharge and the case will close, just like in a Chapter 7 bankruptcy. And then post-discharge is the same stuff that we're worried about in the 7. Make sure the account is updated from the bankruptcy case. Now, Chapter 13 is a little different. They've probably made some payments. So you got to make sure that those payments are all accounted for. You've got to make sure you're not collecting on a discharge debt. You got to make sure you're not going after the borrower for fees that your attorney charged you that you didn't file a post-petition fee notice for. There's a lot of things to keep in mind. That's why obtaining good counsel on Chapter 13 specifically is extremely wise. Your attorneys will kind of shepherd you through this process on each case. So that is a timeline, a general timeline on what a 7 and a 13 look like from beginning to end. So again, high-level view. So we've talked about rights and remedies along the way, but I wanted to bring up a couple more that we either didn't get to or things that I want to spend a little time on. So we talked about planned treatment. If you don't like your planned treatment, you've got to object. So look for the valuation of your property and look for the debtor's use of your property. So Chris, this would be the time for that question that you asked before. So this just goes back to Chris's question of, another listener's question. If valuation matters, yes, valuation matters depending upon your lien position specifically and what the debtor's use of your property is. Debtors cannot cram down a first lien on residential property. So if you hold a first lien on residential property, then on the debtor's residence is what I mean, valuation doesn't necessarily matter to you so much. Other things to keep in mind. You're not getting paid, okay? Should you be getting paid? You might not be getting paid because you're not supposed to get paid just yet, okay? So these are some responsibilities that you have. Your responsibility, and you can do this for your attorney, to know when you should be getting paid. So you're not going to be getting paid until that plan confirms, generally speaking. Certainly on the arrearage. So you may call me and say, Tony, it's been 2 months. Did I file bankruptcy 2 months ago? I've not gotten any payments. Well, there might be a reason for that, okay? Very jurisdictionally specific. If you have a claim on file, is the claim in your name? So we talked about filing transfers of claim. If you bought a loan, if you bought a note in bankruptcy and the payments are going to Bob, and you need them to go to you and you're not getting paid, well, there's a reason why. You didn't file a transfer of claim to get the payments going from Bob to you. So why else could you be not getting paid? Is it time to file for relief from stay? Your attorneys will be able to keep that in mind. And that could be a remedy for you to either start getting paid or to just tell the debtor, you know what, we're done, we've had enough. We want to take this through foreclosure at this point.
Hey, Tony, isn't there certain things that also take priority? Like, I know the trustee fees usually get paid first and a certain other things get paid. So it still could be a few months before you see money if it was like taxes or something. I forget what it is, but there's something like what priority as well.
Yep. That's exactly right. You've got some claims that are ahead of you. So you've got administrative claims ahead of you and then priority claims that are ahead of you. So you mentioned a couple right there. Taxes are going to get paid before you. The debtor's attorney is going to get paid before you, which I find difficult, but it happens. So there are people or entities that will get paid before you, yes. But you should be getting your ongoing payment. When I say that your payments may not be coming in, I'm talking about your payments on the arrears. You should be getting your ongoing monthly payments at that point. So filing for relief from stay. So this is a remedy that you have, okay? Gets the property out of the estate, which we talked about. It's usually resolved with an agreed order, okay? In working with note buyers for as long as I have, you guys just want money coming in on these notes. So a motion for relief from stay, I'm not going to say scare tactic because that's not what they are. They're legitimate pleadings. But sometimes that's the effect of filing a motion for relief from stay. It's a scare tactic. It gets that debtor paying again. It gets you a little bit more money coming in. That bankruptcy may fail, but that act of filing that motion for relief from stay got you more money before that case dismissed. And they're often resolved with an agreed order, and that agreed order is going to say, okay, well, we know they fell behind again. We're going to let them catch up. Here's the way they're going to get caught up. And if they fall behind again, we don't want to have to pay Tony another buku bucks to file another motion for relief from stay. At that point, we want to just get our relief from stay. So it kind of holds the debtor's feet to the fire to get payments coming into you all. And then, again, another remedy with repeat filers. We talked about that at the beginning. I don't want to kind of beat a dead horse with that. But again, check out how many filings they have filed prior to the current filing, and you may have some remedies with that as well. Collection of your attorney's fees from the debtor. We briefly touched on that a moment ago. Attorney's fees are not allowed everywhere. For example, Ohio, you're not allowed to get your attorney's fees from the borrower, which is frustrating, but that's the rule in Ohio. So if you are in a jurisdiction where it is allowed, then you have to file this notice, okay, that we talked about. And that has to be filed within 180 days of the charge being accrued, okay? Now, we can argue over when accrued is. Unfortunately, it's not bankruptcy lawyers, creditors, debtors, and stuff like that are writing these rules. It's congressmen and congresswomen, and they don't know bankruptcy. So they use a word like accrued. Well, accrued can be when I bill you. Accrued can be when you pay me. Accrued can be when you assess the borrower that amount. But generally speaking, in most jurisdictions, it's going to be when the service was incurred. So basically when I bill you, that starts that 180 days. And you have 180 days to file this notice, and then you can collect it from the borrower. You would be collecting it through the bankruptcy. You wouldn't be billing the borrower. It would come in through the bankruptcy court. Again, this varies widely by jurisdictions. And some jurisdictions will not allow all of your fees and costs to be recovered, but will allow a portion of them. For example, the Northern District of Illinois has a trustee, Deb Miller. I'm still going to charge you $900 for a proof of claim and plan review and those pleadings, but Deb's only going to let you collect about $400 of that from the borrower. So if I do that for you in the Northern District of Indiana, and you want me to file this notice of post-petition, this notice, we're only going to file it for $400 because that's all that Deb will allow you to get back. It's just the way that it is. Can I buy or sell a note in bankruptcy? Yes, you can. But make sure you know what you're buying. Make sure if you're buying a debt that's been discharged in a chapter, or you're buying a note, I'm sorry. Let's stick with the word note. If you're buying a note that was discharged in a previous 7, you can't collect on that. You're limited only to getting your property back. So that may change your pricing on that note. Just make sure you know what you're buying. We're going to talk about some costs here next. And those are also things that you should keep in mind when you're pricing a note that is in bankruptcy or a note that looks like it's going to be in bankruptcy. Okay, so those were just some other things to keep in mind for kind of your rights and your remedies that you have. The last topic that we have is costs and what things are going to cost you. I wanted to make sure that we've kind of got everybody up to speed so far. Are there any questions that would be good to ask right now?
So Sophia just asked, and it's at what point, if a loan is in BK, should you not buy the loan if these timelines are important? And is there a point that's too late to do anything? I'll get your answer, and I'll answer after you do as an investor what my opinion is.
Well, it would be different between a 7 and a 13. So in a 7, you would want, if your goal is, if the debtor wants to keep the property and your goal is to get a reaffirmation agreement on, you need to do that before the discharge is entered. So that's going to change your timeline pretty quickly. In a Chapter 13, honestly, if that debtor's paying in that case, and that's a case that's going along well, most of the attorney's fees are at the beginning of the case. So most of the attorney's fees had to do with the proof of claim getting filed, the plan being reviewed. That's that $900 fee that we've talked about a couple of times. So $900 may not sound like a lot, but if you're looking at a note that's only a few $1,000s, that $900 is a lot of money. So it may be more advantageous to buy a note if money is a concern like that, to buy a note after that legal work's already been done.
Yeah, I like to buy my bankruptcies when they've been in it, when the plan's been approved for confirmed for about 12 months.
Okay.
That way, you know that they're probably not a constant filer, and they're slowly starting to, like you said, the fees are already paid, and they're basically now at a point where they're slowly starting to see the light at the end of the tunnel, where they might have 3 or 4 years left on the plan. And then, once you got to remember, once the plan's discharged, all their credit card debt and a lot of their things are out from underneath them. So they'll actually have probably more payments to pay, continue paying the mortgage. And nowadays, a lot of them even will look to refinance, because there's companies that can refinance you now within like 60 days or 30 days after a BK, which is, to me, is insane. But, companies will do it. So, for me as an investor, I like to look at BK 13s that have been, about 12 months and longer. If they're towards the end, that doesn't bother me, because I know you can, again, they're going to be, discharging a lot of debt. Chapter 7s, on the other hand, if it's an inactive Chapter 7, I'm just assuming that you're basically getting an REO. So a lot of times I won't deal with a property in Chapter 7, because my goal is usually to work the borrower. And a lot of times you can also see when you read the court filings whether or not they want to keep the property or not, because that's something that they will put if they want to surrender it or try and work something out. Usually you can find that in the case as well.
Good. Okay, so let's talk about some costs that are involved with bankruptcy. Okay, these are general costs of common pleadings. Okay, these are taken right off of the Fannie Mae fee guidelines as of earlier this month. I typically don't raise my rates until Fannie Mae raises their rates. I don't lower my rates unless Fannie Mae lowers their rates. Our firm tries to really abide by these Fannie Mae fee guidelines, because it's very transparent. These are readily available on the internet. When they increase, that's readily available. You should not ever get a surprise from our firm, or really from any firm, as to what the fees should be. So I'm not going to waste time kind of reading through these. You'll have the slides. These are the general costs of the most common pleadings in bankruptcy. So there we go. I do notices of appearance. So notices of appearance are not a Fannie allowable fee type, meaning that's going to be charged differently by your firms. When we started out 4 years ago, we had a client that wanted us to file notices of appearance on all their cases, and we just came up with a $150 number, and we've since learned that that's kind of a good average number. So we've stuck with notices of appearance for $150. So again, I want to be clear in talking about fee clarity, and that's where that came from. So when must you file a pleading? We talked about these along the way. When a Chapter 13 is filed, you must review the plan and file a proof of claim. You must file a plan objection if you don't like your treatment. You must file a transfer of claim if you acquire a note in bankruptcy and expect to be paid. I'll leave the rest of those musts up there for you to review. These are things you have to do. These are not things that you can maybe do. That's why there's a definite cost to dealing with notes in bankruptcy, because there are fees that you will have to pay. Otherwise, you really run the risk of losing your lien. You run the risk of of a plan that you don't like being confirmed. And what you've bought, what you've completed a deal on, you're not going to see the benefit from because you didn't have somebody review the plan that understood what they were doing. So these are a series of pleadings that you must file. When should you file? Okay, we talked about those as well. If an account becomes delinquent, you should consider refiling for relief from stay. How long are you going to wait to see if that debtor makes that payment? In that Chapter 7 context, consider getting that reaffirmation agreement. Again, it's going to cost you some money. We're going to file a notice of appearance, so that's $150, and the reaffirmation agreement is $250. So that's $400 right there. So we're not talking about chump change. That's good money, okay, in order to get a reaffirmation agreement. But that reaffirmation agreement will allow you to then collect from that borrower post-discharge in a Chapter 7 context. So that, while not a must pleading, is a should pleading. I got a little scenario down there. What did I write here on this one? So if there's an asset. Oh, okay. So I have a lot of my clients don't want to do motions for relief in Chapter 7s because they're pretty short, only 4 to 6 months. Okay. Again, generally speaking, 4 to 6 months. A lot of things can hold up Chapter 7 cases. Nothing devalues a property more than a debtor who is not paying and doesn't want to keep the property anymore. So I hate seeing somebody try to save a little money and not file a motion for relief from stay, and that property just sits there and sits there and sits there. So consider filing motions for relief from stay in Chapter 7 cases, especially if you catch them at the beginning. Then you're really getting the benefit of getting that property back that much sooner than waiting for the discharge to be entered. That's all that I have. How do we do with questions, Chris?
We've got most of them answered throughout what we were going through. So if anyone has any additional questions, feel free to post them. We did have a question that somebody asked was, what are the ways to get the property back if the debt is discharged? You know, besides foreclosure, is there any other way to get a property back?
Well, there's all the state court remedies. You've got cash for keys. You've got a deed in lieu of foreclosure. I mean, you've got things that you can do that aren't collection methods that if the debtor wants to do and is voluntarily doing, you can't force them to do a cash for keys, as you know. But those are remedies that may save you time and money over taking a house through the entire foreclosure process, which, depending upon the jurisdiction, if it's a judicial district or a non-judicial district, could cost a lot of money and a lot of time. So, if you know your jurisdictions, have your attorney or your servicer post-discharge reach out for a cash for keys offer.
So, well, you just mentioned servicer. One of the things that popped in my head was, I know some servicers will do proof of claims. I typically am more conservative, so I have my attorneys do it. And, but do you need to be it sounds like you don't need to be an attorney to do it. Anyone can do it, but I think the recommendation should be from somebody who's very familiar with it. Would you agree?
That's my opinion, and that's my recommendation. Yes. Now, when you say some servicers file the proofs of claim, mm-hmm. I do see some servicers mm-hmm. actually filing proofs of claim. If they know what they're doing mm-hmm. and they're cheaper than me, okay, mm-hmm. maybe that's not the worst thing in the world. Mm-hmm. Some servicers say they do it, but then they go and hire me to do them. Yep. So we file a lot of proofs of claim mm-hmm. On behalf of servicers like FCI, SN Servicing, Madison Management. So some of these servicers that typically note buyers are using, mm-hmm. We're actually the ones filing those.
Yeah. One thing that I didn't realize until it happened to me this week, and you mentioned it a few times tonight, was, I logged in because I've got an account. I forget what the name of the company where you can actually get an account to see your case files and see like the payments a trustee gets. and there was like $4,000 in there. So I was kind of like to the trustee, hey, how come you're not dispersing, the payments? There's like $4,000 in there. And they replied back, they said, well, the case hasn't been confirmed yet, so we can't pay until, any money until it's actually confirmed. And it's been going on like 5 months because there was something where the borrower either didn't, I forget what it was, like he didn't take the right training or he waited too long to answer something but yeah, I noticed that's something that was, I'd say, educational for me in bankruptcy as well recently.
Well, that's a good topic to cover, at a future kind of advanced level kinds of things. That could be kind of some inside information, if you will, if you're pricing a note that's for sale. If it's pre-confirmation and you're doing some due diligence and you happen to see that the trustee's holding on to some money and they're not dispersing it yet because the plan's not confirmed, there's ways to get that money pre-confirmation. So you may be sitting on a heck of a deal that you can pull the trigger on and be able to get at that money pre-confirmation. Because if that trustee has that $4,000 in your case and that debtor dismisses, that money goes back to the borrower. That doesn't go to you. But if you are able to get into court and file some appropriate pleadings, you may be able to get at that money before that case dismisses.
Well, the other secret that I'll throw out there is during this time frame, the borrower might be making payments, but they're not going to you or the servicer. So when a note seller puts out a tape, it may look like there hasn't been payments in 6 to 8 months, which would be non-performing when it technically could be performing. And the other component to it is a lot of times I see these trustees, they almost pay in blocks. It's not always monthly. It might be like, nothing. And then the third month, I might get a check for like $2,000 sometimes. And then you'll see that sporadic payment and people will think, oh, that's a non-performer. But the reality of it is, no, the person's been paying. It's basically the trustee may have gotten lazy or just, didn't issue your money at that point in time. So, those are some of the things that I've learned, my secrets I'm telling people out here when you're looking at some of these things, when you're trying to buy assets in bankruptcy, that you kind of just, you just don't look at it and take it for what, take it for granted what's there. You kind of should look at the big picture and realize, well, that payment they got in 3 months, was basically the 3 months of payment. So was it the trustee or, the person still made the 3 months of payments? It may have just taken a little while.
Exactly.
Okay, let's see. We got a question here. If you're under contract with a loan that's in BK and doing your due diligence, can you review the BK to let us know what your options and what would that cost? So this is, I think, a question to you, Tony, is if they're doing due diligence and there's something in bankruptcy, can they hire you to basically go into, I'll say, Pacer, review everything and kind of see what's what?
We do those very frequently and we charge $100 for those.
Yeah. So, and Sylvia, again, one of the things that we want to do is not to take anything away from Tony, any business, but kind of just go into Pacer and kind of show people around on some of the things like to look at. For example, if you're buying a note in bankruptcy, going in Pacer and seeing the claims register to see, what they did file at the time and to see if there were a lot of objections and kind of see where the case is, because, you'll get a case that's 6 months old and there could be 90 something different, filings just in that BK. There's a lot that goes into it, but also there's a lot of great information, tax return information for the borrower, how much they make, their other debts, if they own other properties. I mean, you can really, it's amazing how much stuff is out there.
Pacer can definitely be your friend, and that doesn't take money from me. I mean, I like an educated client. An educated client is a good client, if you ask me. So, gaining some knowledge on Pacer, and there's all kinds of different courses you can take on how to navigate Pacer. And we'll do a little bit of that. I mean, I don't. My interactions with Pacer are pretty limited, but I'm looking at the same kind of things that you're looking at. So I don't have any necessarily Pacer secrets. But these are all very good topics to talk about next time.
And for people out there, it's pacer.gov, and that's basically where you can search all bankruptcy records. You do need to register, and if you download stuff, I think it's like 10 cents a page. I mean, it's short money, but anybody that's interested in buying notes that are in BK, definitely you want to get a Pacer account. It's a must in my mind to have.
I completely agree. And I mean, you're really dealing with pennies. It's like 10 cents a page. And if you don't charge that much, if you're not downloading that much, I don't know what the numbers are, then you're not even charged. And you're billed quarterly. So if you're below a certain amount, there's no charge. But I mean, for example, I think my last quarter Pacer bill was about $8,500 for a quarter. So we use Pacer a lot. We're always checking Pacer. We're always on Pacer for things for you all. So use us for that.
As a note investor, mine is usually maybe $20 to $30. And typically what it is I'll be looking at a note and I'll go pull the original plan, which might be 20 or 30 pages. So you might knock $2 or $3 right there. And then I may go pull some things from existing files that I have possibly. So, I mean, it's, you shouldn't be spending more than 20 or $30 doing due diligence just on Pacer, which again, that's a drop in the bucket.
Yeah. It's just good common sense.
Yep. Okay. Any other questions from anybody? I think that covered everything. I thought that was, Tony, was an excellent dive into a lot about BKs. And it's kind of one of those things that I see people kind of afraid to jump into. And one of the first notes I bought was in BK because I wanted to learn the process. And I'll tell you, it is a learning experience. But I view it more, there's not a lot of risk in my mind when you're getting something in BK because the numbers are the numbers. I mean, you've got to plan, if you're buying an existing note in BK, the rears are the rears. Everything's already agreed to. So there's really nothing more that they can contest. It's not, like you're buying a note that's in foreclosure and they're going to turn around and file a countersuit against you because they feel that, there was a fair debt collection violation or they don't like the amount and stuff. It's basically, a non-performer on training wheels almost in my mind. So.
Bankruptcy is good. And if it's done the right way, if the trustee's an involved trustee, the trustee's doing all the accounting for you.
Yeah.
I mean, if I were to buy notes, I would specialize in buying notes in bankruptcy. I think they're great. There's a lot out there. I mean, again, a lot of the work, I'm not going to say a lot of the work is done for you, but some of the work is done for you.
Yep. And the other thing too that I'll mention is as part of doing due diligence, one thing I'll look at too is, not only looking about notes that are in bankruptcy, but if there's a borrower that's non-performing, I'll go look to see how many times that borrower has filed bankruptcy.
Yep.
Because in the case of, I've learned my lesson the hard way, similar like Gail had, that, if you see somebody's filed 2-3 bankruptcies in the last 3 years and they're non-performing right now, guess what? They're filing again, and you got to plug in those costs and numbers and timeframes because they're dragging this out. And is that something you even want to have to deal with? So most part now, I'll shy away from those because it's not worth it. So.
It's just going to be a money pit.
Yep.
All your money's going to go to your attorney for attorney's fees.
Yep. And then you're going to basically try and get it back from the borrower. And then if there's no equity in the property, it's basically money that's out the door.
Yep. So, exactly. Well, good. Well, again, thank you, Chris and Gail. I think Gail dropped off, but thank you to you both for the opportunity to be here.
Nope, no problem. And like I said, we'll definitely have you back on to kind of do a little deeper dive into things and a little more insight for people on that. And I think this was very beneficial for others. And why don't we, before we wrap off, why don't you just know, it's up on the screen, but for people who are listening, what's the best way for them to get in touch with you?
Best way to get in touch with me is via email, and I've got my email address there, or just call the office directly. We have grown, so if you've been with me since the beginning, so to speak, getting me on the phone might be a little more of a challenge these days. I'm on the road a lot, but the benefit of that is that we have quite a few attorneys in the office now. We're up to 10 attorneys so between all of our offices and all of our states and all of our practice areas. You'll be able to get to somebody pretty quick and be able to get your questions answered.
Yeah, I was joking with Franco today, talking to him that I told him, I said, I think I'm paying for your contractor's renovation bill this month because he just did like 20 collateral reviews and 3 forfeitures and a few other things for me. So I was joking with him on that. But I saw that you are, renovate, or basically you've got new office space now that you're renovating and so forth. So when's that going to be done?
So we took on some space next to our current space. We had about 3,000 square feet in Loveland, Ohio, Cincinnati, where my office is. And we outgrew that soon after we moved into it. We just recently took over the space next to ours, which is an additional 8,000 square feet. So we renovated the 8,000 square feet. We've moved into there, and now we're renovating the original 3,000 square feet. That's what's going on right now. And then we'll tear down those walls between the two suites, and we'll have one big office of about 11,000 square feet. And we have 23 people, I think, in our Cincinnati office. Okay. We're at about 36 firm-wide, 10 attorneys, and just trying to do the best work that we can, and trying to help everybody out.
Yep. Last question, I'll let you go. Just out of curiosity, and you don't need to answer this. Is
Sure.
I was just curious if you're looking to expand into any more states besides the Ohio, Kentucky, Indiana, Michigan, and Illinois. Just out of curiosity.
That's a good question, and probably not. Okay. Illinois was an easy add because I was licensed federally in Illinois, and we had a significant mortgage creditor client want us to go into Illinois.
Yep.
So that was kind of a no-brainer.
Yep.
We've looked at Tennessee because it's an adjoining county. We've looked at West Virginia. We've actually been asked to go into West Virginia by a client, again, a significant client, and we passed. I think at this point in our careers, we're happy where we are and expanding the volume that we have in those jurisdictions.
Good. So, thank you again for joining us this evening on this episode of the Good Deeds Note Investing Podcast. And again, if people need to reach out to Tony, you can reach him at tony.sottile, Sottile, at sottiliandbarilli.com. And we'll have all his contact information in the show notes. So thank you all for listening.